Today we'll be talking more about the process of filing. You've heard me talk about office actions, but what exactly is an office action? Simply put, it's a statement from the USPTO that there's a reason they believe your mark should not be registered after examining it. So they are refusing registration, but giving you an opportunity to respond. Beginning December 3, 2022, you will have 3 months to respond to an office action. If you want an additional 3 months, you will need to pay $125. Not every case gets an office action. In fact, the ideal scenario is receiving a notice of allowance after examination. However, examining attorneys conduct their own searches that may disagree with your clearance search. Office actions can be as simple as requiring a disclaimer, which can often be remedied via phone call and an examiner's amendment, to as complicated as the dreaded descriptiveness refusal. The USPTO may ask you to disclaim certain wording because it merely describes a quality, characteristic, feature, purpose, or use of the applicant's goods. For example, if the word bottle appears in your bottling company's trade name, the USPTO may ask you to disclaim the bottle portion of your mark. What this means is you cannot claim an exclusive right to the terms that others may need to use to describe the goods and/or services in the marketplace. The disclaimer does not physically remove the disclaimed portion of the mark. It just means you can't claim an exclusive right to use the word bottle apart from the entire mark, for example. The USPTO may find your specimen to be unacceptable for a variety of reasons. I previously recorded a vlog describing what a specimen is, and it can get kind of complicated. If the specimen is a screenshot of a website, for example, the specimen must include the date accessed and URL. If you fail to do this, you can expect to receive an office action. If your specimen fails to show the mark as used in connection with the goods and/or services specified in the application, you can also expect to receive an office action. You will be given the opportunity to produce a substitute specimen along with an affidavit or signed declaration stating the substitute specimen was in use in commerce at least as early as the filing date of the application. In other words, your response to the office action can't be a new specimen you just came up with after the fact. You may get an office action for a mark that is primarily merely a surname. What this means is that typically you can't just register a last name because it takes away the ability for others to use their own names. The following 5 factors are used to determine whether a mark is primarily merely a surname. First, whether the surname is rare. Second, whether anyone connected with applicant uses the term as a surname. Third, whether the term has any recognized meaning other than as a surname. Fourth, whether the term has the structure and pronunciation of a surname. And fifth, whether the term is sufficiently stylized to remove its primary significance from that of a surname. Now that phone books don't really exist anymore, you can use databases such as Lexis to search for surnames. Sometimes you might think a word is just an acronym, but the examining attorney says, hey look, there are 11,000 people with this surname, and you'll get a primarily merely a surname office action. What about McDonald's, you might be thinking? Well, if there's acquired distinctiveness due to use of the mark for goods and/or services for at least 5 years, it can be registered. You might get a likelihood of confusion office action, also known as a Section 2D refusal, that the applied for mark so resembles a registered mark that it is likely a consumer would be confused, mistaken, or deceived as to the source of the goods and/or services of the applicant and the owner of the already registered mark. Hopefully, this one does not come as a surprise if you did a thorough search and that you have all of your arguments prepared and ready to go to rebut the examining attorney's position. Just one more example is the scary Section 2E1 merely descriptiveness refusal. You've worked hard, you've done your research, you weighed your options, you weighed your pros and cons, and still, you see the words registration is refused because the applied for mark merely describes a feature or characteristic of applicants' goods or services. Yesterday was Halloween, so this is an appropriate office action to discuss. Responding to this type of office action is going to take some time to research and respond to, and the response could very well be a lengthy brief. If your arguments in response to an office action do not persuade the examining attorney that they were wrong, the USPTO will issue a final office action. All hope is not lost though, because you can respond again or appeal to the Trademark Trial and Appeal Board. Even though responding to office actions may not be the happiest part about trademark practice, still, trademarks are fun.